The Senate has confirmed a historic judicial nominee. The judge in question here, Katie Lane, is making history because she received a not qualified rating from the American Bar Association in President Trump's second term. The Republican National Committee lawyer and former Montana Deputy Solicitor General was rated unqualified by the ABA due to her limited legal experience. The association's committee said that she fell short of the 12 years of experience as an attorney standard for a federal trial court judgeship.
All right, we got Khalif Rhodes back with us today, our chief legal analyst, to talk about this. Khalif, the concern here, as Annie mentioned, limited legal courtroom experience here. Is that when you look at confirming a judge? I mean, on the surface, it sounds like, hey, that's pretty important. You should have both of those things to be confirmed.
Yep.
How important, as an attorney, is that on the level of being a federal judge?
Extremely important. I mean, as someone that ran for judicial office and at a number of times went up and had an opportunity to be appointed for higher judicial offices, I'll say, the conversations that you have with attorneys, they're asking these same type of questions. Well, what type of experience do you have? And I remember going through my process of talking to seasoned retired judges, and they were asking questions, and some of the answers I didn't have, and I maybe didn't line up to where they wanted. They may have liked me and really wanted me and even were pushing me, but they were like, okay, are you there? And that was, I mean, on our superior court level, we're not talking about the federal bench, which is a lifetime appointment, but I can speak from my own personal experience, but I also can speak to clerking for judges. I've worked in the federal system. I recognize what these folks do on a daily basis is not something that's easy, and it's not something that you can learn on the fly. Every job you go to, you don't have to learn how to do it, but you need to come with some baggage. Typically, that baggage will be an understanding and an appreciation of how the law works, how it's applied, and how you can now transition that to being on the bench, someone that's calling balls and strikes. Hard to call balls and strikes if you don't even know the rules to the game. And so when you talk about experience being required on the federal bench, is extremely important.
And what other qualifications does the ABA look at in making these kinds of appointments?
A lot of their process is not required. I looked at their list of what they go through, and they're looking at interviews, they're looking at past writings, they're looking at a number of things to make sure that they put someone in there that won't be not controversial, but will be non-fair and impartial, which is required. I mean, just to put this in perspective, and Jason kind of hit on this in the beginning, you're saying that this has been occurring since 1953. That's when the ABA Standing Committee on Judicial Process has been around. President Eisenhower went to the ABA and thanked them for this process at the time of how happy he was that they were helping non-attorneys help pick people that would go sit in these positions, because if you're not in that industry, you really don't understand what's required. And so there has been a significant shift from the thinking to now the kind of walking away from the ABA's role in this process. Yeah, it's not required. It's advisory than any more than anything. The Constitution says the Senate confirms, the President nominates. So the ABA doesn't have a constitutional role, but they have a very important role. Since 1989, 11 folks have been given that non-qualified rating. 10 of them have been President Trump's individuals that he's nominated. So he has consistently put forward individuals that have not met the ABA standard. But what the Republicans have done is now shifted the argument away from courtroom experience to more now, and as they did in her nomination, her experience on clerking, her experience as a solicitor, her law school experience. They went to those things, even in her hearing, to talk about why she was qualified and why the ABA committee got it wrong.
Khalif, I want to make sure that we're walking the narrow line and talking about the legality of this here. Do you envision a different path towards the confirmation process where it is codified that the ABA has to give a rating towards whoever the nominee may be?
I don't see that happen. I mean, Congress wouldn't want to add additional rules on top of themselves or say, now I have to go to someone else and take away what's congressionally, I should say, constitutionally given. Right. What I can tell you is I don't think they would add that. What I will say is this isn't the first big one. I think one that was even kind of more shocking than this was this woman, Catherine Mazzelli, 33 years old, 5 years experience. This woman has 7. She only had 5 years and had never, ever had led a trial in federal court at all. And she was confirmed and nominated. And so the argument, and this is what Democrats said during the hearings, is that the Republican parties have pushed and not to get political, but this is from their hearing, has pushed like merit-based advancement. But it depends on what the merit is. The Democrats are saying this individual doesn't have the merit on any standard. Republicans during the hearing said, again, that her merit was less about courtroom experience, because we're not looking for the best trial lawyer, but more academic experience. And that's why they confirmed.
Interesting. All right, some insights into how the ABA works. Kali, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.